Good morning, everyone. I hope everyone had a wonderful 4th of July week. I know I did. I was off on vacation and had spent some time with the family. So that was really nice. It could have been a little cooler, but that's okay. Um, as we stated 2 weeks ago, we were looking at possibly moving the streaming to a noon production, but we really didn't get much feedback on that. So we're going to keep it at the 9 a.m. and we're going to do that through the summer and maybe reevaluate this for the fall. Before I turn it over to our guest speaker, Jim Dawson from Miles Stockbridge, I want to share something that we heard this week from one of our members. One of our members who's been using UltraTax for many, many years, and thank you, Patrice Lincoln, for calling in. She seems to feel that we might have a little bit of a glitch with UltraTax. So apparently, if you're using UltraTax and you have a client who is using or has the Maryland State Pickup and has turned 65, um, she has found that UltraTaxes really may not be calculating the pension exclusion correctly. Now, this is only for years 2016 and 2017 is what Patrice has found. So, looking through her clients, she has found where four of them who had the Maryland State tax pickup it did calculate the exclusion incorrectly. So, if you are using UltraTax, I would suggest you go back and look at those clients that have the Maryland State tax pickup, and maybe reevaluate and review those tax returns. Now, Jim, thank you again for joining us this morning. I want to turn the program over to Jim Dawson. Jim was the assistant director of the legal department with the controllers for many years.
Many years.
Yes, yes. And then he moved over to private practice about 2005. Jim currently works for Miles and Stockbridge, where he handles a wide range of law issues, including federal, state, and local tax matters. Jim, thank you for joining us this morning. I know you're going to be addressing the new Supreme Court ruling, so I'm going to turn it over to you because you have a lot to talk about.
Morning, Sandy, everyone. It's kind of a new situation for me. I'm not used to talking without crowds, without a live audience. So I've told everyone here that I'm going to start asking questions of them, and let's see if they can answer the questions.
I'll go like the noise.
But it's good to be here. It's good to be with Sandy and MSATP again. So this morning we're going to be talking about South Dakota versus Wayfair and the recent Supreme Court decision that was issued just a couple weeks ago, June 21st. But before we get into Wayfair, let's talk about what Wayfair does or does not do. And the one question that everyone wants to know is this a new law? And the answer is no, it's not a new law. The sales and use tax has been around for a very long time. In Maryland, it was back in the 1930s it was enacted. What Wayfair does is affects the state's ability to require a remote seller to collect and remit the tax on purchases into a state. So let's talk a little bit about sales and use tax. There's two components to the sales and use tax. You have the sales tax, which is the tax that's generally collected when you make an in-person or online purchase, and it's done at the time that the transaction is consummated. The vendor assesses and collects the tax on behalf of the state or local jurisdiction, and then they file their returns and they remit the tax to the state. The use tax, which is just the flip side of the coin of the sales tax, is if you purchase something and tax is not collected, and you're using that in the business, it's not an exempt purchase, then the use tax is due, and the use tax burden is on the purchaser. And they have to either, if it's a business, include it on their sales and use tax return. There's a line on the form for reporting your untaxed purchases. Or you can have a business where you buy items for resale and you can use a resale certificate, but you end up using a product in your business because it's now used and not resold. The use tax is doing that use of the item. So that's the type of purchases that would be reported on a use tax return. Some states, New York, Virginia, and others, have a line for individuals on their individual income tax return.
Yes, I've seen.
Wanting to know what your untaxed purchases were during the year. Some states use kind of a threshold if you don't want to account for each purchase you made based on your income. There's a range that you can use as to, a percentage of your income that you put down as a use tax liability. And in Maryland, while there was some discussions years ago about putting a line on the return, they don't want to put sales tax and income tax on the same return. So they developed the form ST118A, which is the consumer use tax return. And that was the same thing, designed to allow individuals who make purchases either out of state and bring the item in state, or buy something over the internet or through a catalog where the tax wasn't collected because the vendor wasn't required to collect a Maryland tax, for them to remit the tax due.
Okay.
So Wayfair only deals with what we call nexus, or that connection with the state, with the vendor's connection with the state, and the state's ability to require that remote seller to collect the sales or use tax on behalf of the customer and remit it to the state. So, and this goes back 50 years. Just run through a very brief history because we don't want to go too long this morning. Sandy has already told me that she's going to cut me off at a certain time.
Yeah, we got to get to the meat.
Yeah, and she wants to get to the meat. She's not the potatoes person.
That's right.
So in 1967, National Bell Assess was one of the first major cases dealing with this. And the Supreme Court held that the Due Process Clause and the Commerce Clause required that a vendor have a physical presence for a state in order to require that vendor to collect the sales and use tax on behalf of the vendor. Fast forward 10 years to complete auto transit, and the court, looking at the Commerce Clause, designed a 4-pronged test. And the first of which is that the tax has to apply to an activity with a substantial nexus to the taxing state. And then we get to Quill versus North Dakota, which most of us are familiar with.
Yes.
And this is from 1992. Now, the other thing that, if you've been involved in taxes as long as I have, the other thing that you know about 1992 was that was the Jeffrey case, which was an income tax case, come out at the same time. And so those that were doing income tax were focusing on Jeffrey. Those doing sales tax were focusing on Quill. So it was kind of a unique time period for those of us in state and local tax. But Quill kind of revisits National Bell Assess and Complete Auto Transit. And they were looking at a North Dakota requirement. They went after Quill. Quill sent computer disks into the state that had its catalog on it and allowed customers in North Dakota to purchase items electronically through this catalog. And the North Dakota Supreme Court held that it did satisfy the physical presence test, that there was enough of a connection there with this disk to require the state to collect the tax. Well, the Supreme Court had a choice. They could either overturn the North Dakota Supreme Court, or they could overturn National Bell Assess. And under the principle of stare decisis, they decided to overturn the Supreme Court in North Dakota.
Interesting. Okay.
But they did say that the due process clause and physical presence aren't the same thing, that you don't need to have a physical presence element, or that the due process clause did not have a physical presence element. But they did sustain the due process or the Commerce Clause requirement that you have a substantial nexus and that the physical presence was necessary to establish substantial nexus under the Commerce Clause. But what it did, it invited Congress to address the issue. They're like, we're going to follow National Bell Assess, but if the Congress wants to provide some type of guidance, if they want to come in and state that you don't need to have a physical presence, or you do need to have a physical presence, we're going to leave that up to Congress to make that decision.
Mm.
Well, was it 26 years later, give or take? Congress hasn't done anything. The principle of physical presence has been there for 50 years now. And, but as we'll get into Wayfair, the court had an opportunity to revisit that. And how did we get here? There's been a significant lack of compliance with reporting and remitting the consumer use tax. Since 1992, there have been a lot of changes in the way that people act in the marketplace. 92, we were still going into our neighborhood stores, the brick and mortar stores, purchasing books. I guess there were CDs back then.
Yep.
Software. You could download a whole lot on the computer in 92. And I think our modems were maybe up to 4,800 baud at that time.
Yeah, we were feeding that mouse cheese every once in a while.
Yes.
Yeah.
And Windows 3.1 had just come out. So yeah, there's been a lot of changes in the last quarter decade.
Yes.
So a lot of businesses being done outside of the community, outside of the state. So you have a lot of people have always been kind of transient, but people would buy things out of state, bring them into the state for use, and not remit the use tax. Now, for those of you, I know this is not what you want to hear, but if you buy something in a state and the sales tax is 4% and you bring it into Maryland, Maryland's rate's 6%, you're supposed to remit the 2% difference to Maryland.
I do all the time.
A lot of people do.
Yeah.
But a lot of people don't, and that's why we're sitting here today. Now, the other thing is, we won't ask you if you've been filing the ST118A. I don't want to get you into trouble. This is being recorded. So, but if you buy something in a state where the tax rate's 7 or 8%, you bring it into Maryland, Maryland's not going to give you a refund.
Oh, see, so I balance it out. I take the two together and I come out with a number.
Yes. You really want to put that on you? Sharon, I hope you're not listening. So we've always had catalog and phone sales, and delivery was into the state by common carrier, and that wasn't considered physical presence because it was a common carrier. Then you have states like Delaware, and it's one of our neighboring states, and everyone's seen the billboard if you've gone to Ocean City, the tax-free jurisdiction. So you had jurisdictions that did not have a tax or had a lesser tax promoting that effect. You had online sellers that are advertising tax-free purchases and anything to create sales, and that kind of rubbed the states the wrong way. And we do a lot of online or internet purchases, things that we used to buy in a tangible format, your records, CDs, I guess,
your books,
movies,
sure,
software, everything is downloaded now. It's because we want that instant gratification.
Right.
You don't have to worry about finding a CD player or to connect to your computers or devices that don't have them,
right,
to download the software or to install the software. So it's just easier. And I think most of the online purchases is not to avoid taxes. It's the convenience.
It's the ease.
It's the ease.
Sure.
And also it's you don't have to go from bricks and mortar store to bricks and mortar store to bricks and mortar store to find the items you want. You can sit in the comfort of your home or office and purchase from thousands of companies and just have it delivered to your door the next day or in a couple
and it's
days.
Beyond just looking for it. It's also comparing prices. You don't have to go from down the street to this need.
You don't have to cut coupons.
Yes, exactly.
Or look at ads. So
right.
I mean, it's more convenience, I think, than tax motivated. But you still have the companies out there advertising it, and which is not good for business. It does have a negative effect on the bricks and mortar businesses. So the states, almost immediately after Quill was passed, the states were looking at ways to get around this physical presence standard, and especially as more transactions were done online.
Mhm.
So they looked at agency nexus. Okay, do you have someone doing something in the state on your behalf? Okay, we're going to say there's a physical presence. Then you had click-through nexus, the Amazon
Oh, okay.
issues with connecting with companies in other states and having links on your website to the Amazon site, because they had a physical presence in the state and they were providing an open door to the marketplace. They started going with click-through nexus. And then they were looking at locations of your hardware. Are you renting from a server farm in Virginia? Or do you own a server that's located in a server farm in Virginia or some other state? I use Virginia. Virginia has a lot of
Sure.
tech. And the states would say, well, because of the location of the hardware, you have a physical presence. You have something physically located. And then you have one of the more recent situations where they're going after cookie nexus.
This is a new one.
If the company
Yeah.
places a cookie on your computer, that now there's something that company has put on your computer in that state. So now we're going to have cookie nexus. So it's getting interesting. And
Yeah.
then, the Supreme Court recently ruled in direct marketing versus Colorado that Colorado's requirement that the vendors that are selling to customers in Colorado that didn't have a physical presence were required to report the sales, not collect the tax, but do a reporting requirement to the state as to who purchased what, and also provide notice to the individuals that their sales were subject to use tax in Colorado. And in that decision, Justice Kennedy basically in a footnote invited someone to get a case before the Supreme Court so that the court could revisit Quill.
Ah.
And
that's where Wayfair comes in.
Well, that's where Wayfair comes in.
Mhm.
And all the jurisdictions were then rushing to get some type of standards out there that they could get the court to look at. And South Dakota just happened to be the one that made it into the Supreme Court. They developed a statute that provided for economic nexus, but they had safe harbors because they were looking at the burden. Because one of the things you have to look at in the Commerce Clause is what kind of burden is it placing on interstate commerce. So they developed some safe harbors. If you have $100,000 or less than $100,000 of sales, or less than 200 sales within the state, then you weren't subject to the requirements. But if you had 100,000 or 200, then or more, then you were over the safe harbors and you had a requirement.
So it's less than 100,000. It's not 100,000 or less.
No, if you have 100,000 or more sales,
okay,
then
you
have
fit
economic
it. Okay.
nexus.
Okay.
Sales receipts, and then 200 of individual sale transactions.
Gotcha. Okay.
But they also said, we're not going to apply this retroactively. We're going to make it prospective. So there was actually there was an injunction in there that said that, as long as this is pending or being litigated, we're not going to enforce it. And the other thing that I think is very important here is that South Dakota is one of the members of the Streamlined Sales and Use Tax Agreement. And I'll touch on that in a little bit.
Okay.
But where we're at is with South Dakota enacting this law, there were some immediate challenges to it. And because of I'm going to fast forward here a little bit in the interest of time, it was challenged. It worked its way up through the South Dakota courts. And the courts held that under Quill, the Supreme Court standard was that you had to have a physical presence. An economic presence was not sufficient. And they ruled that the statute was unconstitutional. South Dakota petitioned the Supreme Court for cert. Cert was granted. They held their oral arguments this term. And of course, the decision was issued on June 21st, shortly before the end of the term.
Mm-hmm.
And not surprisingly, Justice Kennedy authored the court's majority opinion. And the court actually criticized Quill's decision as being flawed in the finding that physical presence was not a necessary element of the substantial nexus requirement. And they also disputed as unsound the contention that the physical presence requirement is clear and easy to apply. What is physical presence? Is it a cookie on your computer, or is it a warm body walking through the streets? So
Right.
even though most of us think of physical presence as that warm body,
Right.
the states did not feel that was the same definition of physical presence.
Right. It could be virtual.
Yeah, it's a virtual presence.
That's right.
And there's a lot of different ways to conduct business, and we do have economic nexus standards for income tax. So it's not a unique or an innovative approach. And it also said it was just totally unworkable in the online marketplace. And so the physical presence standard puts bricks and mortar retailers at a competitive disadvantage to solely online and remote retailers. So the court looked at the specific statute and what South Dakota had done and ruled that it avoids the discrimination and undue burden on interstate commerce. There was a safe harbor. There was an injunction that stayed the enforcement until the litigation was resolved. There was no retroactive application, so you're looking at prospective only. And it was also a member of the Streamlined Sales Tax Agreement, which has in place a mechanism for compliance. And they also have kind of uniform definitions to make it a little easier for compliance.
Okay.
And so based on that, the court held that physical presence was no longer necessary in order to satisfy the Commerce Clause. So that was issued June 21st. And of course, there's been a flurry of activity.
Oh, yeah.
Courts are, or not the courts, the states are now looking at their laws to determine what, if anything, they need to do in order to be able to satisfy the standards that potentially were set down in Wayfair. Now, I don't think Wayfair addresses all the issues. There's going to be a lot of potential litigation left on this because they didn't come out and say that you must have a safe harbor of $100,000 or 200 in sales. They didn't say what the actual thresholds were. They just said that the way South Dakota statute was written, it did not violate the due process clause.
Okay.
Or I'm sorry, the Commerce Clause.
Okay.
So there's still those, I guess the door is still open for more constitutional challenges to states' nexus standards if those standards are different from South Dakota's. So what's next? The National Conference of State Legislatures had a meeting on June 29th, and they approved a page of principles advising the state to not to begin collecting or enforcing the sales and use tax collections until January 1, 2019, and should not make it retroactive. They said that they should simplify the registration process. I don't know how many people have tried to register for sales tax in different jurisdictions. Most of it has to be done online now. There's no streamlined process. There is no uniform process. You basically have to go out there in all the different jurisdictions,
And do
not
each
just
one.
the states, because some local jurisdictions also have sales and use taxes, and they actually administer their own taxes. And so there's got to be a simplified registration process. And they want to issue guidance for the retailers.
So let's move on to, so how is this
Yeah.
going to be affecting Maryland and
The-
Maryland businesses?
Well, first it's going to be interesting to see if Congress responds.
Okay.
So that's the next step. Is Congress going to step up now and do something? They could potentially come in and overturn Wayfair. They could enact legislation that says, no, you got to have physical presence. Or they could do something at the opposite end and say, you don't even need to have safe harbors.
Oh, wow.
If you have sales in the state, then you're subject to the tax. Or they could do something in between. And they could also require the states to become members of the Streamlined Sales Tax Agreement. So what happens in Maryland? So we're located in Maryland. What's going on in Maryland these days? Okay. First of all, if you're a business in Maryland and you have remote sales, you have to look at all those other states in which you have sales going in to find out what their laws are. And because you may, under the laws of those jurisdictions, be required to register and collect and remit the tax.
Now you're saying that the other states. You're also saying it also be jurisdictions in that state.
Yes, state
Okay.
local jurisdictions.
Okay.
When I say state, I'm
In the whole
thing.
Yes.
And because it's important to note that even though there's only 50 states and 5 states don't have sales tax, there's actually, as of October 2017, according to Veritex, from their reporting requirements. And Veritex, if you don't know, is one of the 3 jurisdictions that has kind of a package to help with compliance in all the different states.
Right.
According to them, in October 2017, there were 10,814 different sales tax jurisdictions.
Wow.
Yeah. Fortunately, a lot of them work through the states, kind of like Maryland. Maryland only has 1 tax. Actually, it's got 2 if you're in Western Maryland or Ocean City, but that's, for all intents and purposes, Maryland has 1 tax jurisdiction. Missouri has 1,393, but the winner is Texas with 1,594.
Yahoo.
Yeah.
Giddy up.
And our neighboring states, Pennsylvania has 3, DC, of course, has 1, Virginia has 174, and West Virginia has 43.
Oh, wow. Okay.
So what's Maryland done?
Yeah.
Well, recently, earlier this month, Maryland issued a tax alert, sales and use tax alert, regarding the Quill decision. And they just basically said that Maryland has the ability to impose its sales tax collection to the extent of the Constitution.
Okay.
Yeah. And what does the Constitution provide?
Exactly.
Well, we're not sure yet, because we know that what South Dakota did satisfies the Constitution, but we don't know what Maryland's going to do yet. The most recent bill that was introduced in this past session had a $10,000 safe harbor, 200 sales, but that bill was not enacted. So
it was at 10,000 and 200?
No.
Or.
It was or.
Okay.
So it was 10 per the dollar volume was 10% of what South Dakota's was.
Okay.
So, but fortunately that wasn't enacted.
Okay.
Sorry.
No.
Let me catch up to myself. Okay. So where's the controller stand now? The controller is evaluating its options. There's a question that's circulating whether or not the state needs to enact a statute, or because of the fact that the controller can collect up to the extent of the Constitution, can they do it by regulation?
Oh.
I think they have to do one or the other, because there's a policy in the state, well, there's nothing really currently in the state that provides for economic nexus.
So for the novice people, if it's statute, it has to go before the session.
If it's statute, it has to go before the general
But if it's
assembly.
regulation,
Then the controller could do it, and they could actually do it on an emergency basis.
Exactly.
And get it in a little faster. I think the goal in a lot of the jurisdictions is to try to have something in place sooner than later. But I would hope, just to allow businesses time to get up to speed, that they don't force or don't make it effective until January 1.
Right.
I mean, complying with over 10,000 different sales tax jurisdictions, especially in states like Louisiana that has parishes, where the parishes administer their own taxes, some of them do. It's going to be a little hard to get up to speed and get the systems in place. People are going to have to revamp their online sales point of sale systems to account for the remote collection of sales tax. So I'm not sure what's going to happen. There's been some talk about a special session to kind of maybe pass a bill for
in 2018, a special session.
well, Not for this,
Okay.
but for sports betting.
Ah,
So if they kind of move forward with the sports betting, would they kind of tag on or something for sales tax nexus?
right.
So we're not sure what's going to happen. So everyone's got to stay tuned to the developments in the state. Maryland did adopt the streamlined sales and use tax. They did not become a member. It was adopted in 2002 or 2003. And it provided that there was a threshold or a trigger that it would become effective when Congress enacts a statute allowing for the states to require remote sellers to collect. Well, the statute doesn't comply with the law because Congress didn't do anything.
Right.
It was the Supreme Court. So that immediate trigger is not part of the statute.
So logically, Maryland is not part of the streamline since Congress did not do it.
Correct.
It was done by
Yeah, they
the
have
Supreme Court.
yes, they have
That makes
adopted it,
sense.
but they have not. I mean,
Okay.
for Maryland to get involved in streamline at this point, they would have to do another review
Mhm,
of its sales and use tax laws,
mhm.
look at the definitions. The one big thing that's always been a major factor in Maryland is the way Maryland's tax is assessed. Maryland's tax is a bracket tax, not a true rate. So if the tax is on increments,
Mhm.
it's at a 6% rate, but you always round up.
Okay.
And under the streamlined sales tax agreement, it's conventional rounding. And that would cost Maryland millions of dollars, even though you're only talking about a cent here and there. The volume just adds up. And it was such a loss of revenue to the state that they could not change that
Okay.
without being able to collect remote from the remote sellers.
Mhm.
Um,
So at this point, for Maryland, we don't see we really don't have anything definite.
Not from the state of Maryland.
Yes.
Again, for businesses that are in Maryland that have remote sales, they're
Right.
going to have to look at the other states in which they have sales to find
Right.
out what they need to do in those states. For their and hopefully
Hmm.
your Maryland-based companies are collecting and remitting Maryland sales tax currently. But for out-of-state companies
Hmm.
that are selling into Maryland,
Hmm.
like maybe our bordering states or any other state, they're going to have to wait and see what Maryland does, what thresholds, and when it becomes effective.
Right. So I mean, like you said, this is not just a Maryland issue. This is a national issue, and
It's actually an international issue.
an international
because,
issue.
what's going to happen with the international marketplace? Are the states going to try to collect from companies outside of the United States?
Hmm.
Are they going to try now to collect from Canada or Europe? And are businesses going to move their operations, their sales operations outside the U.S.?
Right.
I mean, again, from the standpoint of the business, they're collecting the tax.
Right.
The cost to them, there's the two costs to businesses is the cost of compliance
Hmm.
and the cost of audits. You're going to now be subject to audits from all these different jurisdictions.
Oh wow.
And if there's any deficiencies in the collection process, then the company can be held responsible for the tax, interest, and penalties.
Mm.
And a lot of the businesses are on small margins, profit margins. These taxes and the cost of
The penalties.
compliance, interest, penalties, and even
it's going-
cost of compliance is going to be cutting in
Sure.
to their profits.
Profits. Sure. Wow. Really interesting stuff, Jim. Really interesting stuff. Did we get any questions? No questions. Okay. Well, that's okay. We're going to move on. I just want to say that I want to thank Jim for being here this morning. And as I said, this is going to be a very interesting subject. And
Mhm.
actually, we have put together a seminar on this, which is going to be a seminar and a webinar. And that's going to be on September 25th from 3 to 5. And it's going to be in Owings Mills. So we have that is now up on our website now. So I think, Jim, you've already touched on it. But we could see things happening very quickly.
Yeah.
And so that's why we put this together in September. So if you're interested in attending or actually going online and attending through a webinar, you can register on our website right now at www.msatp.org. So I really feel that this is going to be a subject matter that's hot, and I believe this seminar and webinar is going to sell out quickly. So,
Can I have one final comment?
yes,
We've been talking about the states going after the collections. But there's one recent development that I think everyone's going to find interesting.
what's that?
New Hampshire is going the opposite way. Governor Sununu has stated that, but I should preface this, New Hampshire does not have a sales tax. So they are going to have a special session later this summer to try to enact legislation to protect citizens and businesses of New Hampshire.
Really?
Yes.
Well, that is going away a different route, aren't they?
Yes. But they want to make it so that before a state can require one of the businesses in New Hampshire to comply with the out-of-state laws, that they have to petition the state to make sure that that state's laws are constitutional and reasonable and will not have an adverse impact on
what a
the
concept
businesses.
they're coming up with, huh?
Yeah. So it's not all states trying to collect the tax, but of course, like I said, New Hampshire doesn't have a sales tax.
Exactly.
They're trying to protect their own marketplace.
Interesting. Wow, that
Stay
is some.
tuned.
Yes, stay tuned. That is some interesting information. And one last note: we did hear about from the IRS. There's a new scam out there, and the new scam is that they're reaching out to tax practitioners, and they're saying that they are tax and accounting associations, and they're asking you to provide your password and your username. They've already seen this happen in Illinois, Iowa, New Jersey, North Carolina, and Canada.
Wow.
The Maryland Society of Accountants takes the security very seriously. And if you get an email and it says it's from us and you question it, please do not hesitate to call us and to verify. But like I said, so just be aware of that. They're just going from all angles here, from all angles.
And all
So
it takes is one or two people to click the
Oh,
button
yes.
or to pick up the phone and call and provide the information.
Yep. So again, I want to thank Jim for joining us this morning. Thank you so much for being here. I
Oh.
truly appreciate it.
Thank you for the invitation. It was my pleasure.
Now, next week, what we'll be addressing, we are going to be talking about the new 1040 form. Woohoo! Exciting stuff happening. And also the new W-4 form. So again, some interesting stuff coming down on the federal level. I want everyone to have a wonderful day today. Thank you for joining us. And I think we're gone.